You folks really know how to clear out a room.
This is case 2013-0874, James Conant et al. Versus Timothy O'Mara et al.
The record should reflect the fact that Justice Bassett is disqualified from this case. Mr. Gordon?
May it please the court, I'm Joshua Gordon. I represent Timothy O'Mara, who's here today, the defendant here, and I've reserved a minute for rebuttal. Your Honors, this is a statute of limitations case. The statute of limitations in any case starts ticking when the plaintiff knows of their injury and knows the proximate causation.
You don't find the trial court's finding of a fraud exception to be viable?
Well, there is a fraud exception is viable, but you need, in order for a fraud exception to be viable, it has to be after discovered fraud, not fraud that was known the entire time. And the Conants knew they had a cause of action at the latest in 2007. And at that time, they had 30 days or a year to attack arbitration in the Superior Court, 3 years to bring malpractice, although they waived that. And this is a statute of limitations case. Having taken no action, the Conants now seek to sidestep that with this with fraud, but it has to be after discovered fraud. And in Adams v. Adams, that's the New Hampshire case where a husband, libelant, published the notice for his wife that they were, notice of divorce in a newspaper he knew she would not see. And years later, discovered the fraud. Same thing in Hazel Atlas. Years later, it was discovered that the Persuasive Journal article was, fraudulently planted. And in those cases, the duped party had no other remedy. Here, there's no after discovered fraud.
If I'm understanding you correctly, you're saying, and I went back and read the arbitrator's decision and the dissent, and you seem to be saying that the trial court here effectively had another trial of really sort of the same, where the same issues were in dispute before the arbitrator, and that to say, well, this was fraud. I mean, if I'm understanding correctly, Mr. O'Mara never admitted he hasn't admitted that he's committed a fraud. It's just that the PCC, I understand, has made that finding, and we affirm that finding. But he never admitted that, and it was your opponent's position at the time of the arbitration that he committed a fraud by lying about saying I had an agreement for a $2 million fee.
There were several potential frauds at that time. One was exactly that, and one was the tale that Mr. O'Mara told at arbitration. But of course, that was known at directly at the time of arbitration. That alleged or found lie was known, and we know it was known because then Attorney Bassett wrote a letter in 2007, March or April or May. That notified the PCC of all these things, not only the conflict of interests that gave rise to McCool, but the alleged lie that Mr. O'Mara allegedly, or you affirmed, that he told during the arbitration. And that was known. That was known back then, and this is just a straight-out statute of limitations case with nothing weird going on except this allegation of fraud, which isn't after discovered. I think my brother's
Isn't it arguable that the fraud continues even to this day?
Does the fraud continue to this day? I don't think so. I think it's at a certain time, and it was known then, and a long time ago. And we're not here.
The money hasn't been disgorged, correct?
The annuities have been attached. We're not here relitigating McCool. Back in 2007, Conant may have had a good argument that O'Mara should not have gotten any fees due to the conflicts of interest. But with competent counsel, the Conants explicitly waived to McCool by several things. By agreeing that the $11.5 million settlement was, quote, a reasonable result, that's their words, by agreeing to not bring a malpractice action, by agreeing to a $750,000 fee, by agreeing to arbitrate up to another $1.25 million, and by not appealing the arbitration finding to the Superior Court after either 30 days or a year. And that was the time to raise the McCool issue, and they might or might not have prevailed. But in 2007, they made a choice, and now later with new counsel, they want a second bite of the apple. Moreover, McCool was a fee award that was part of the underlying probate case, like any
Might it
probate
have been
case.
reasonable to anticipate that the PCC matter would have resulted in the relief they requested? In other words, disgorgement?
Well, insofar as they asked it there, then we have a res judicata issue, same parties, same issue, and maybe,
I'm
maybe not.
just wondering whether that might not be a reason to toll the statute of limitations.
But do we toll the statute of limitations until the PCC finishes its work?
I don't know.
I mean, that's a long time. And I think we have to take the standard of review that this court employs in disbarment cases, because this court doesn't make any findings of fact. It only issues sanctions. And that's, Rule 37 is all about that. And so there's no new information occurred by virtue of this court's decision. There's nothing new. It was the only new thing we knew was what the sanction would be. So
Well,
I don't see how you could toll because they knew their.
Okay, so what we do know as a result of the decision is that not only did Mr. O'Mara lie to the arbitration panel, but we observed that equally significant was his course of conduct, starting with making an unauthorized settlement offer. So we went back to the beginning, essentially, and said that warranted the discipline that was imposed. Now, if the PCC doesn't have the authority to disgorge, then where does, if disgorgement is merited, where does that come from?
Oh, easy.
A malpractice case?
A malpractice case, or you bring a McCool type of action back in I suppose it would have been at the end of 2006 or the beginning of 2007, right when the Conants entered the agreement to arbitrate. They knew then that there was unauthorized settlement demands. They knew all of the conflict of interest. That was all the reason that they wanted to arbitrate the additional fee. They knew all of that. I think by looking at this, or by allowing a new lawsuit to go forward now, and it's a new cause of action filed years later. It's not like McCool. And it's applicable to all representations. It undermines and maybe supplants the traditional ways that we have of addressing fee and representation disputes, but with much lower burdens and perverse incentives. It supplants traditional malpractice. Here we have forfeiture without proof of damages or causation, and I think both have been waived. Second, it displaces the Bar Association's fee dispute resolution system. Here we have forfeiture after a week of supposedly binding arbitration. Who's going to go in and enter that sort of fee dispute? And third, it creates perverse incentives for the attorney discipline system, because then you have people complaining to the system, hope for whatever ethical issues they can dream up for the purpose of getting their money back. And the rules of professional conduct we have to...
Let me ask you this. Let's assume we agree that going into the arbitration with the assistance of counsel, the Conants agreed that the $750 was acknowledged to be owed, and that the only issue going into the arbitration was what to do with the escrowed amount.
That's how it was.
Okay, so those are the facts on the ground. Going into the arbitration, now we have a finding that Attorney O'Mara lied during the arbitration. So I'm asking myself whether it makes sense, given the lie, which of course the arbitrators didn't know about, whether the arbitrator's decision should be vacated.
Well, they might know about it. They kind of did. The dissent talked about
But
it.
there wasn't a
Not
definitive
definitive.
finding.
There was some squishy language.
Yeah, right. Should that be, should the arbitrator's decision be vacated and then the matter remanded? I'm just thinking out loud here.
Well, you know what?
For a determination of what a reasonable fee under the circumstances would be. In other words, $750,000 would remain if we accept your argument. But then, because of the lie to the arbitration panel, that gets vacated, but then we need a remand for an ascertainment as to what a reasonable fee would be. Something along the lines of the dissent by the arbitration panel. But we wouldn't be bound by that dissent. It seems to me we could vacate it. And then a court would have to look at it and maybe decide that there is nothing further that is reasonable under the circumstances.
I have two answers to that, Judge Conboy. First is the Conants had the opportunity to do that. The statute gives them a year to take arbitration to the Superior Court, and the agreement gave them 30 days. So within that time, they should have done that, and they should have done that.
And isn't there another problem here that the arbitration panel made a finding, if I read it correctly, that Mr. O'Mara believed he had an agreement for $2 million. That is certainly, I mean, that if they thought that he lied, they wouldn't have, I mean, it seems to me at the most, you might say that they were saying, you know, maybe he unreasonably believed something, but not that he subjectively lied. So they've made I think they did make a finding by saying that he believed it, that he was not lying. If you believe something, you're not lying about it.
Well, I think you can see this a couple of different ways, and there's statements in both the majority and the dissent where maybe they relied on what he said, but they used that word believe, which I understand to mean it's not an objective lie. It's just a belief. It could be a religious belief, whatever it is. It's merely a belief. And then the dissent was categorical that the majority did not believe Mr. O'Mara. So, but whether they did or not, the opportunity to attack that was a long time ago. And the fraud thing, I really think my brother is it's just sand, she's trying to throw sand in your eyes. It's like, look over here at the fraud, but that's for those fraud doctrines to undo finality of judgments are for when you could not know about, you could not uncover the fraud, years later or whenever later. Here they knew about everything at the time. And the second answer to your question about remand is if Mr. O'Mara loses here, just all the way loses, there needs to be a remand for how much forfeiture, because the judge here forfeited the entire bit. But
Including costs? Including costs, Mr. O'Mara did a lot of work. He did a day in a life video, he did interim damages, he did client counseling, trial preparation, did the mediation. He saw this to the very end, and the Conants admitted that he achieved a reasonable result. So, that's the entire, if I all the way lose, you still need a remand to rejigger that.
Thank you.
Thank you.
All right, well, then, the case is submitted and the court is adjourned.